Hi, welcome everyone. My name is Jay Logel, and with me is Jen Beidel. We're both at Dykema, and welcome to today's Dykema Litigation Institute and Dykema Drive's presentation on Do the Charges Fit the Crime? Criminal Liability Risk for NHTSA Reporting. Now, if you want to ask any questions during the discussion, feel free to put them in the Q&A box down at the bottom of the screen. And you're always welcome to send follow-up questions to Jen or I in our emails. And all this material will be part of the program provided after the discussion. Some of you are attending for CLE credits. To obtain the certification of attendance, please submit your record to the learning source at dykema.com, and we'll help you with that. Speakers for today are Jen and I. I work in automotive regulatory compliance matters, and Jen works on.
I work on white-collar criminal defense matters and internal investigation matters across all regulated industries.
She has a big job. That was a slide of our nationwide coverage to let you know that we have attorneys licensed in all these jurisdictions, so we can help wherever you have a problem. So the topic for today is Cruz's deferred prosecution agreement, and it came across my desk, and I was candidly surprised that reporting to NHTSA resulted in a criminal prosecution. And I went down the hall to talk to Jen because of her expertise in white-collar crime matters and automotive criminal matters. And we talked about it, and we thought, yeah, this is a topic that's probably worth discussing with our clients and doing a presentation. So we're really happy you're here, and please ask questions as we go. For those of you who don't know the background, NHTSA has this reporting obligation for autonomous driving vehicles and ADAS systems assist the driving, and it comes out of a series of investigations that they had, and they felt like they needed to have a better insight into when crashes were occurring in vehicles equipped with ADAS and technologies. In this case, Cruz was operating a AV, and the allegation is it failed to describe the events of a collision with a pedestrian under the SGO. In its 1-day and 10-day reports, Cruz limited its description to the point where the vehicle initially came to a stop and contacted pedestrian. And it didn't describe the subsequent post-collision movement of the vehicle out of the lane of traffic, and they eventually drug the pedestrian under the vehicle. Also, in its initial meeting with NHTSA, Cruz didn't mention the post-collision movement of the vehicle, and it showed a portion of a video, and that video didn't show the post-collision movement either. But later that day, Cruz did provide a full video showing the entire event with the post-collision movement. That same day, Cruz submitted a 1-day report, and it did not describe that post-collision movement until the 30-day report. So Cruz was penalized by NHTSA and the California Public Utilities Commission civilly. Cruz was found to have not reported fully in the 1-day and 10-day SGO reports. Under the SGO, if you fail to respond truthfully or fully, you're subject to civil penalties. And NHTSA found 4 potential civil penalties, and Cruz paid a $1.5 million civil penalty. Also, it had a consent order where it agreed to substantial additional reporting beyond the SGO. And then with the California Public Utilities Commission, it paid the maximum civil penalty for failing to report timely. And at that point, I thought that was sort of the end of the event. Then I saw that the Assistant U.S. Attorney for the Northern District, California, had brought a prosecution and entered into a deferred prosecution agreement with Cruz. It alleged under 18 U.S.C. 1519 that the SGA reports were misleading and inaccurate. They had a tendency to influence the administration of NHTSA's oversight and regulation of AVs. The penalty was a $500,000 fine, which is pretty modest. And there was a remediation, safety compliance, and reporting requirements, which were very consistent with the consent order with NHTSA. You know, my perspective is these were fairly low-key penalties for the crime that they were alleged to have committed. And I think it reflects the fact that General Motors' oversight of Cruz, they corrected a lot of the issues that both NHTSA and I think the U.S. Attorney saw in the Cruz operation. And I think GM can be applauded for taking that action, and I think these penalties reflect their good works. So when I saw this, I thought, I never considered SGO reporting to be a potential criminal liability issue for manufacturers, and it caused me to question what sort of risk OEMs were running, both with NHTSA reporting and generally. So what was the statute that they were charged under? It's a Sarbanes-Oxley Act passed in 2002. It says whoever knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry into any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation or proper administration of any matter within the jurisdiction of any department or agency of the United States can be fined and imprisoned up to 20 years or both. So that's the act that or the statute that they were charged under. So what did Cruz allegedly do? In the deferred prosecution agreement, they were alleged to have omitted facts that the AV had a secondary movement, and that omission rendered the report inaccurate and incomplete. The next question is, well, what does the SGO say about post-crash reporting? What's the requirement? And when you look through the SGO and all the instructions, this is the one statement that's there. It says, in the narrative, you have to provide a written description of the pre-crash, crash, and post-crash details, including the direction of travel if known. That's it. There's no other direction or instructions about post-crash reporting. Were the SGO reports false, or were they narrow interpretations? The narrative stated the Nissan Sentra made contact with the pedestrian, and then the pedestrian launched in front of the AV, the Cruz vehicle. The AV braked aggressively, but shortly thereafter made contact with the pedestrian. This caused no damage to the AV. The driver of the Nissan Sentra left the scene shortly thereafter the collision. Police and emergency services were called to the scene. The pedestrian was transported by EMS. And I think what this reflects is a perspective from Cruz that the collision was with the Nissan that was in the next lane. That's their view of what the collision was about, and that's sort of where the collision ended. And when you look at the DPA and you look at some of the background material, it's clear that within Cruz, that was the narrative or the perspective throughout the company. So how did Cruz allegedly obstruct justice? The DPA says the statements and documents described were misleading and inaccurate, and had the tendency to influence the administration of NHTSA's oversight of AVs, including whether NHTSA would initiate an investigation regarding the crash and the scope of the investigation. Now, one of the things that you see in the DPA, and I think is important for people who are lawyers counseling auto companies, the role of the lawyer was highlighted over and over. It was recognized that the lawyer knew NHTSA would be interested in the secondary collision, but that it just wasn't reported in the SGO. And they really focus on the role of the lawyer in that space. So if you are advising clients about SGO reporting, you should really consider your role. Now, the question we had, and Jen and I were debating this, is how much did the SGO really have the tendency to influence NHTSA's oversight? The accident happened on October 3rd, and by October 16th, NHTSA opened an investigation. And on the day of their meeting with NHTSA, Cruise did provide a full 45-second video that showed the entire movement scenario, even though it wasn't contained in the one-day report. Also on the October 3rd, there was a lot of media coverage. You couldn't miss it. On October 6th, Forbes had a big article describing the pedestrian being drugged under the vehicles, and that got nationwide reporting. And by October 13th, NHTSA had conversations with Cruise where NHTSA said we're aware of the dragging and the subsequent movement. And then on the 16th, NHTSA opens the investigation. So we sort of question how much was NHTSA influenced in this space. And one of the things that Jen and I talked about was, suppose in their SGO report, Cruise had referenced the video and just said, for more details, please see the attached video. Would that have been enough to help avoid some the criminal liability? So there's a lot of questions in my mind about how much content needed to be in the report, and with just a little bit of massaging of the wording, would it have been a very different outcome?
Jay, I think that was a really good point about, what precisely is in the reporting. I think what at least criminal enforcement is going to look for is what's on the face of that document. And so if it had said the AV made contact with the pedestrian, for more details about that contact, see the attached video, I think that would be a much harder case for a prosecutor to make about it being incomplete, so long as the references are there. All these materials were provided, they're just not necessarily cross-referenced in that report. So if you're only looking at the completeness of the report, that's what they grabbed onto as prosecutors to say there was an area to fill in. But the next thing we want to talk about is whether this is even a correct interpretation of the obstruction of justice statute 1519 that was applied here. And there's a few relevant cases for that. And then we'll talk a little bit more about the practical realities. Why would these prosecutors include this kind of charge? How do they decide what to charge? And does the current political environment impact that at all? So the first case we want to talk about is Fisher versus the United States. In this case, this is one of the January 6th cases, but we're going to talk about it for reasons that don't actually have to do with the circumstances of that. So among the charges that were brought against Fisher was a similar count under Sarbanes-Oxley, 18 U.S.C. 1512 C2. Like 1519, 1512C has a more specific list of the ways you could obstruct. That's in the subpart 1. You alter, destroy, mutilate, conceal a record, document, or other object to impair the object's availability or integrity for a proceeding. Or 2, the more general, otherwise obstruct or impede a proceeding. So the case in Fisher, the court asked the question, how broad is number 2? Is it, as broad as it appears to be just on its face, you obstruct any official proceeding, and it can apply? Or is it more narrowly construed to be equivalent to the types of things that are listed in number 1. So Fisher was convicted on that count and ultimately appealed. And in that appellate decision, the court decided to read that section too narrowly. They said in obstruction cases in general, they resist reading those cases as coverall statutes, meaning there are a lot of different obstruction statutes throughout the criminal code. And if you had one broad enough to say otherwise obstructing justice, then you wouldn't need any of those other more specific obstruction statutes. So the Supreme Court says we need a more narrow reading of 1512. That's also consistent with the statutory history here. 1512 is designed to cover things that are more like the specific list in number 1 about mutilation, destruction, etc., of a record or document, not about other obstruction of an official proceeding. And so the Supreme Court decided that 1512 did not apply here. This defendant was not accused of having altered a document in any way, just otherwise obstructing justice here in terms of the results of the election. And so the Supreme Court said that specific charge could not apply. They even referred to this as an elaborate pump fake. That's what it would be if section C2 was applied in the literal way, meaning there would be this list of 4 highly specific ways you could obstruct justice. And then section C2 would essentially say, no, just kidding. You can obstruct justice any way possible. And so C1 wouldn't have any meaning. So when we look at that in comparison to the statute that was charged here, 1519 similarly has this initial list of alters, destroys, mutilates, etc., a record, document, or tangible object to impede an investigation. And then there's this catch-all term that was applied in Cruz of or proper administration of any matter. Now, 1519 itself hasn't been specifically interpreted in this way yet, because there was a case, Safarinia, that attempted to go up on cert to the Supreme Court on this issue, but the Supreme Court denied cert. But I think similarly to the Fisher case, the Supreme Court, if they heard this issue, would be likely to say that proper administration of any matter has to be construed in the context of manipulation of some kind of record, document, etc., in an investigation, and not more broadly to include any kind of administration of the matter. So there is this initial question of whether the statute should even apply as broadly as it applied in the Cruz matter.
Hey, Jen, we've got a question,
Yep.
and I thought I'd just pause and answer it. The question is, did the SGO issued by NHTSA reference the potential for criminal penalties for failure to properly report? And the answer is no. The SGO references civil penalties under the Safety Act, but it did not reference criminal penalties. I hope that answers your question. And Gina Gelman, if you have follow-up, please let us know. Thanks, Jim.
So we wanted to talk next about a little bit more of the practical realities of how does a charge find its way into a document or DPA and indictment. Let me say I was a prosecutor in the Southern District of New York, so I worked through some of this. And there are a lot of decisions that go into what kind of charges to bring. Some of them are based on prosecutorial discretion. What kind of charges is the individual prosecutor familiar with? What types of charges are the easiest to prove? That's why you see a lot of wire fraud, mail fraud charges in most every white collar case. Those will come up. Prosecutors are used to charging those. They know the types of evidence and law that apply in those charges. And so you see them repeated. Then you might see some creativity to add a charge or two, maybe to impact the length of the statutory maximum, maybe to impact, to add a mandatory minimum. So if you add, for example, an aggravated identity theft charge, you automatically get a mandatory minimum charge. Or maybe just because of the optics in a particular industry that you want to make sure you're you publicly will look like you're taking this conduct seriously. So that's the decision making at the line level, the individual prosecutor. They often have levels of supervisors weighing in on a case, especially if it's going to be as publicly reported as this one was. So you might then get pushback from the supervisor of your unit or from supervisors up the line about adding a particular charge. They might send you back to the drawing board to research some of those charges. In some cases, depending on what kind of charges you want to bring, the individual U.S. Attorney's Office will also be referred to a division of the Department of Justice in Washington for input. So, for example, every tax charge that ends up in indictment has been vetted by the tax unit in D.C. I'm not sure that would have applied here, but sometimes it does. And then all of those decisions go into how to charge. A big factor is past performance, whether there are other issues, similar issues in that jurisdiction or otherwise, whether they think a company might be a repeat offender or not, that might work into the decision making. In terms of the Trump administration versus prior administrations, both really the first Trump administration and the current one, in the Department of Justice's guidance documents, the Trump administration says essentially all prosecutors are directed to charge all crimes to which the facts apply, and especially to include the most serious, so the ones with the largest mandatory minimum or the largest maximum sentence. The Biden administration, for example, and also the Obama administration had a more case-by-case approach where the prosecutor and the office could really determine what's most appropriate for this set of facts. But in the Trump administration, the guidance is and will continue to be charge the most serious thing that you can. So I think this kind of concern is most important to be aware of in the Trump administration because Section 1519, for example, has a much higher mandatory maximum sentence, statutory maximum sentence than some of the other charges that are available. And so under this Trump mandate, prosecutors would be told essentially you should add this 1519 charge because it would increase the statutory maximum. Of course, the prosecutor still has the discretion to ask themselves whether the facts apply to that specific charge. So it's not like now they always have to bring that in anywhere that it's close. They can say, look, I considered 1519 and it doesn't apply here. They would do that kind of thing in what's called a prosecution memo that you would draft before you bring any case. And in that memo, you might tell your supervisors, I think these three charges apply. I've also considered 1519 and it doesn't apply for this reason. So it's not like it's mandatory in the Trump administration that now we're going to see 1519 charged in a lot of things, but there is this approach that is recommended that all charges that can be added are added. We're obviously seeing in the media resistance from different U.S. attorneys' offices at different levels to Trump administration policies. So maybe some of this will take time to roll out and maybe it will only ultimately roll out in certain jurisdictions, but it's something to be aware of. The question is here, will other AUSAs use the cruise DPA as an example? That's certainly possible. I think especially if you're going into a new area as a prosecutor, you would look to examples that are available in your jurisdiction and also publicly that you might be able to use as a mechanism to determine what charges are applicable. So prosecutors might be in a particular unit focusing on a particular type of crime, like frauds or securities fraud or terrorism, but they're generalists beyond that. They don't just focus on a particular industry. They might be working on a healthcare fraud in the morning and an automotive case in the afternoon, and they're not particularly experts on either industry. So especially if this is your first automotive case as a prosecutor, you would go looking around for examples of the types of things you could charge. So the DPA is out there as something that could inform prosecutorial decisions in that regard. But I will say that in the Northern District of California, I would think it's most likely to come up because now they have that example in their own jurisdiction. And, a prosecutor might ask their colleagues in the office, have you encountered this before? What did you use? And, then they end up looking at this particular DPA and using that as a way to decide what to do going forward. Jay, back to you on other NHTSA requirements.
Sure, thanks, Jen. One of the things that I looked at in preparing for this were some of the other criminal penalties that other OEMs had paid over time and the nature of the charges. 1519 was just not commonly used before. And I think that is part of the surprise. And I don't know, Jen, if that's something that I should think of as being a significant change, or is it just a matter of there's a lot of obstruction of justice charges and you just pick the one that seems to fit the fact set as best you can?
Yeah, you do try to pick the charge that fits the set of the facts as best you can. So I don't know that it's so surprising in that respect. It is surprising in application in this particular situation. It seems like it was likely applied to bring a more serious charge to the table in a set of facts that, to me, especially based on the Fisher case and the application of this statute, is a bit more tenuous here. So I'm not as surprised that 1519 was applied, period, as I am that it was applied to this particular set of facts, especially if you're reaching a DPA. That seems like a fairly aggressive move from my perspective.
Thanks for that. Another question, I'm not trying to put you too much on the spot. One of the things that's concerning to me out of this, and if I were advising, clients about it, is the SGO is just sort of a standard reporting obligation, right? There's lots of reporting obligations. We're sort of focused on NHTSA here, but companies have lots of reporting requirements and obligations. There wasn't an open investigation at the time. Should, from your perspective, is that a common approach or from prosecutors, or should we take that this was a more aggressive approach, or how should I think about it?
I think it's fair to think about this as more aggressive than typical, but certainly not unheard of. I do think it's important to train those members of your staff that are doing typical reporting functions, that the most important thing in those functions is completeness and truthfulness, however you can achieve that. So certainly in this case, it does not appear that there was any intention to hide anything. They had given the video was there, it could be watched by anyone. So, it's just, it seems to be more like an unintentional wording choice as opposed to any effort to conceal, in which case, talking to your folks about, take a step back from what they're drafting and ask, does it really tell all of the relevant facts? Or are we approaching this a bit too much like a press release where we want to put spin on the facts? I think we want to get the spin out of these typical reports, because what the Department of Justice has been telling us in guidance now for years, if not decades, is what it wants from corporations is clear and truthful reporting and coming forward with issues completely and quickly as soon as it finds them. So I think in that environment, anything that could give a prosecutor an argument of delay is the most concerning thing. So here, where there is, an investigation starts and then the 30-day report does say something a bit more fulsome, that's how part of the problem could arise. So I understand these are routine. There are tons of things going on. It may not be practical to address every single report, but in general, if you have the opportunity to train folks on that completeness point, I think that's critical to do.
Thanks for that. Hey, we've got another question. It's in the past 4.5 years since the NHTSA SGO was issued related to AV. How often have either civil or criminal penalties been imposed against manufacturers for your either failure to report or fulsome reporting? I haven't done full sweep to see if there are some minor reporting violations, but this is the one that stands out. I don't see NHTSA coming forward with a lot of SGO civil penalty charges. And so I think it's a great question, but the answer is it's a very rare event. It just isn't happening with any frequency. And to this point, there have been several investigations, many investigations actually in the last 4.5 years with NHTSA that have been generated out of SGO reporting. And so it's not as though NHTSA is shy about opening investigations based on an SGO report. That happens really frequently, and we've done some studies that show how SGO reporting has really escalated the number of, in particular, preliminary evaluation investigations by the Office of Defect Investigations. So I don't see a lot of penalties related to the SGO. What I do see is a lot of NHTSA investigations being generated out of the SGO.
Yeah, what I would add to that, Jay, is, we are not very far out from this particular SGO, a matter of months. And the criminal life cycle is much longer than that. I mean, we're talking about years for things to catch up. So if the concern is, will other prosecutors catch on and add things out of this criminally, I don't think we're quite there yet. There have been civil penalties, certainly since this SGO, about inaccurate reporting on other reporting forms. That's almost always present in any civil action. And so it's more a question of, will that bridge the criminal divide? And I think it's too early to call.
That's helpful because this, to me, back to the question we just saw about have there been lots of other civil penalties out of SGO reportings, and the answer is no. And then this one where NHTSA did take action, did it, penalize, had a consent order, put a lot of oversight over crews, and then for the criminal penalty to follow closely thereafter, I was just surprised. But it was such a big public topic, right? That my experience is when something's getting a lot of publicity, it's hard for a lot of government agencies or prosecutors to resist, getting involved and looking at their responsibilities and say, do we have a role in something that is so high profile and raising a lot of issues?
Yeah, the other thing is relative to the volume of cases that U.S. Attorney's offices and the Department of Justice are bringing. The ones that involve the automotive industry are a tiny, tiny piece of that. And so when a prosecutor goes into this industry, they probably don't have much experience doing that before, unless they're in a specialized unit in the Eastern District of Michigan that, does a ton of automotive cases, for example. And they don't have very many to look for in terms of examples. So if this was a case in the pharmaceutical industry, for example, where, there are many more prosecutions there than there are in the automotive industry, you might say, this one's not going to have any impact. They won't see it. It's just one of many. But it's a good thing for the automotive industry that there is a low volume, but then when there's a low volume, they're more obvious when things are unique.
Yeah. Another question that I'm thinking about, and I appreciate your thoughts. It is clear to me reading through all the background on this cruise event, both some of the internal cruise evaluations, what the DPA says. One of the issues that drove a lot of concern was the role of the in-house lawyer in this space. And in preparation for the meeting with NHTSA on October 3rd, before the one-day SGO report was filed, there was discussion about NHTSA is going to be interested in this. The in-house lawyer said NHTSA will be interested in this post-collision movement. And I think there's a concern that the lawyer raised it. The lawyer also was part of the review process for the SGO reports. The lawyer participated in the meetings. The issue was not brought up in the meeting, wasn't raised and edited in the reporting. Does the lawyer's activity heighten scrutiny compared to just having, and I'm not denigrating engineers in any way, but will prosecutors say lawyers should have exercised more control over the reporting process versus the business people or the engineers who are part of that reporting?
Yeah, I think that's fair. In almost every circumstance, the court and prosecutors will hold lawyers to a higher standard. They are considered to know the law and to be in a position to apply it appropriately. So I don't by any means intend to comment on the propriety of the actions of the in-house counsel here. I don't think we know enough, right? It's a fast-moving situation. Yeah, they may very well have been well-intentioned and thought that producing the video provided all the information. So, not specific to this, but if you have a lawyer in any way involved in a reporting requirement, then I do think that's a time to exercise additional care, because if an issue comes up, they will certainly go back and say, your lawyer was involved on this day and you didn't, then 28 days later you reported it, or whatever those facts are. That is certainly something that will be held against a company in a prosecution. So in terms of the point of training employees to handle this, training your in-house counsel that might interface with those teams and documents is also really important, because if they come in with the attitude of, this is something that will be scrutinized, so we have to make sure it's complete and that we're giving all the details in the best possible way, that's going to help you avoid risks. Certainly there will be situations where no lawyer was involved and there's still a reporting issue, but hopefully you're flagging the biggest risks anyway, and training the lawyers to provide that advice would be helpful.
That's a great point. And when you review all the materials in the background to this, there was a repeated theme inside Cruise that the video told the story, right? And they really felt like making the video available, whether it was with NHTSA, California Public Utilities Commission, City of San Francisco, all the people that they were interacting with, all the different agencies, they tried to use the videos to say, here, this is what happened. And they had some technical problems making the video work on the very first day, but that was sort of an attitude or a perspective that I think influenced a lot of decision-making at Cruise. Was, well, the video should answer all the questions. We don't need to write a long, detailed narrative. I think one of the lessons I take from this is, while the video's important, helpful, may even avoid some of these risks, the obligation to be careful about your wording and your reporting obligations is really critical in this space.
Yeah, I agree with that. And I think it's the written word that really commands the most attention in the reporting situation, even though the video is obviously the best evidence of what happened. Sort of by analogy, I was just working on another case where a prosecutor got in trouble for not turning over potentially exculpatory information contained in a video. Even though the prosecutor turned over the video, the court said, you didn't highlight that to defense counsel appropriately. It was hidden in a bunch of videos, and you knew that that particular line was potentially exculpatory, and so you needed to point that out in writing or directly in a conversation with the defense counsel. I think this is somewhat analogous in the sense of, you know, they're saying, don't make us watch the video to find out the answer, put it in the written report. I think by extension, it's also fair to say, unless in the written response you say, you know, to see the full account, go to the video. I do think that would be a fair way to get around what they're saying here.
Yeah, no, I appreciate that. You know, another observation, comment about this space on the role of lawyers. GM had its ignition switch recall issues about a decade ago, and there was a report written about what happened at GM, and it's called the Valukas report, written by someone at General Block. And one of the things it emphasizes was the unique role of lawyers to sort of watch over what the business is doing and counsel and be very proactive in that space, and make sure that reporting obligations and relationships with agencies are going well, people being fulsome and in the discussions. And so I think this theme that the lawyers involved are under a higher scrutiny, have a higher duty, and will be looked at after the fact as should have acting in particular ways. Everyone should be cognizant of that.
Yeah, definitely. And I mean, I don't want anyone to hear that as, you know, it's too risky to include lawyers. I think on balance, they're avoiding more risks than they're creating, but, you know, it's something to be cognizant of nonetheless.
Yeah, and yeah, I mean, in both cases, the criminal sanctions happen regardless of what the lawyers did. I just think the role of lawyers is important in these spaces. You know, when I thought about this, and I used to be in-house, right? And I thought, wow, think about all the reporting that an OEM has to do to NHTSA. And this is before there's, you know, an investigation going on. And this is just to NHTSA, but as I said earlier, there's all sorts of regulatory reporting and administrative reporting that goes on. And this is just an outline of some of the major reporting just to NHTSA. And a lot of these things, just like the SGO, where it's helping NHTSA identify potential safety defects, helping NHTSA identify when they should open an investigation. For example, all the early warning reporting, reporting of monthly communications, descriptions of safety recalls, you know, including description of the defect, the scope of the remedy, how the remedy works. All these sort of things are in part helping NHTSA identify whether there should be an investigation, whether there are vehicles outside the scope of the recall that should be also included, whether the recall itself is effective in remedying the defect. All these things, I think, have the same function to the SGO. And when I think about that, I think, wow, if you're conservative, tight in how you're reporting some of these things, it seems like you're opening up the company to similar sort of risk. And I think that then goes to a real evaluation of who's filing these reports in your organization. What sort of training do they have? What sort of process is being followed? How thorough is the data gathering process? And I think when you look at these topics, my reaction is the legal team needs to have some oversight or understanding of this in order to provide good advice around whether the process is working adequately, whether there aren't some areas for improvement. When you're interpreting regulatory requirements, who's doing that? I've seen situations where some engineering organizations want to take a very strong role in interpreting regulations internally, and I think that's a role the lawyers need to make sure they play the right role there. If there's a draft review process, who's doing it? What role do they play? How much authority do they have? Are you elevating issues when you see a potential problem? And when there's a controversy here, I think one of the lessons from the cruise event was the lawyer saw that NHTSA would be interested in this, and I think when I'm not critical of the lawyer, I don't know everything that was going on. Things were happening at such a fast speed, but there was just this narrative internally that the video should tell everything, and I think that's a point where, as a lawyer, you have I think a responsibility to speak up and go, that may not be the perspective of some of the regulatory and law enforcement people. Also, an issue of updating when you have new information. Things, the SGO is a one-day report. And I know companies struggle with what do you include in a one-day report because you haven't confirmed a lot of things. There's a lot of allegations or stories or lore that's going on in that very quick period. I mean, in the cruise example, people were up all night investigating, trying to look at videos, trying to gather information, and it was just such a fast-paced event. It's okay to update things, and it's okay to come forward and say, hey, we need to update this. We missed it. And I think, at the 30-day SGO report, that's what they did. And I think that helped a lot to ameliorate the penalties that were sought in the deferred prosecution.
Jay, I would just add there that prosecutors are always looking at every case from hindsight, and they're just looking at what happened before based on the language on the page. So, if it's an issue that you don't have all the information because you haven't been able to watch the video because of a technical issue or whatever it is, the more you can do to put that just transparently in the report, one line of we're continuing to investigate, among other things, we need to access this or that. That's going to help prevent the hindsight bias that can result when you're reading whatever is written on the page. And the prosecutor tends to come at things from the perspective of, is there something fishy here? And so the more that is there, just openly telling them, no, there was no bad intent here. This just wasn't finished by the time of the one-day report. I think that would be helpful. The other thing I was thinking as you were talking about these reporting duties is it's important to evaluate, but I don't think we're suggesting that every single report needs the same level of scrutiny. I definitely think, prosecutors have limited resources, certainly, and they want to get to the cases that tend to be the most serious. So, a way I would think about it is, if the New York Times found out about this, would they care? If not, the prosecutor is probably not going to care either. But if if there could be a report in the New York Times, it could spin off publicity, it could spin off a prosecution. Those are the times when you want that heightened, scrutiny. So certainly safety issues, that kind of thing, are the types of things that prosecutors would be most interested in.
Yeah, it's interesting in the cruise situation, they were very proactive in getting to a lot of agencies within 24 hours, having meetings, having discussions, talking through with them. So it wasn't as though they were not willing to engage and didn't recognize the need to participate with the agencies and the government officials who are interested. I think it part comes down to the internal narrative that happens when you're in the heat of the time and the perspective. And in hindsight, it can be viewed as you said, that hindsight bias can say, well, you should have done this. And I think people were anxious and tired and trying to hit all the different agencies at the same time. And I've been in those situations, and it's a real challenge. So,
yeah, there's some interesting guidance from a lot of U.S. attorneys' offices recently that heighten their desire for self-reporting And most of them make clear that what they mean is self-reporting to them directly. So if you go tell NHTSA about this, it's not necessarily going to get you off the hook in the Northern District of California. So obviously it is a stressful time period. All these things are going really quickly. But if later, when things calm down a bit, you realize maybe there was an issue, maybe we should have reported a bit more, I would include on your self-reporting considerations, at least, do you need to go to the U.S. Attorney's Office and report it, or to somewhere DOJ and report it? That can be difficult to determine, given that lots of different U.S. Attorney's offices could be interested in, some automotive issues obviously are nationwide. But if there is a particular location where something happened and you could have an issue to self-report, it might be worth doing that directly. I think for the most part, those tend to evaporate unless they're the most serious conduct that you're self-reporting. You tend to go in and report and then not hear much follow-up to that.
Yeah, and I appreciate what you're saying, but I think about being the lawyer who comes to the business and says, oh yeah, I really think we ought to go talk to criminal prosecutors about something that I think probably in most circumstances, you think this is a civil matter. It's a matter with the regulatory agency. It really doesn't have, like when we started talking about this topic, I said, I never would have thought that the SGO 1-day and 10-day report was a criminal matter. It just would not have really been something I thought about. I would have thought about talking with lots of investigative agencies and making them aware. And that wouldn't be the most popular probably piece of advice because everyone's afraid. It's like, oh no, you're opening the box, right? Of maybe they don't know, maybe they don't care, and you just cause them to pay attention. So that's a tough balancing act, isn't it?
Definitely. And it's not one size fits all. It very well could be that in this kind of situation before this case about the SGO reporting, you would advise folks not to go in and report to the criminal folks. But now that this does exist, if a similar situation happens, the advice could be different. So I think you need to assess the facts, what cases have come before, what your company's relationship to the U.S. Attorney's Office. Have you had prior issues? Are you under a DPA? All those factors go into the decision making about how much you need to tell them.
Yeah, this opened my eyes to expanding that scope of who you need to touch in those circumstances. There's lots of entities that are going to be interested in, and how do you keep them aware and keep things from getting out of control, for lack of a better word.
And we are in no way endorsing the reasonableness of the policy that you have to go to all these different entities to report. I think it's very unworkable in practice, but that still remains the situation that we're dealing with.
Yeah, and I think Cruz actually did a really good job. This got a lot of publicity. They knew it was going to be highly scrutinized, and they wanted to make sure that they were communicating with the agencies they had relationships with, that they knew were getting questions from the media. So part of our job is to help those agencies, protect them from feeling like they're not able to answer some basic questions. So I think that is one of the lessons I take away from this, is think more broadly about who might be involved and put that in the consideration process. I'm not saying you go to a federal prosecutor every time there's a topic, but ask the question.
Yep.
Well, I think we're at the end of time, pretty much, and I don't see any more questions. I'll leave it open. Anyone else have any questions or follow-up or anything about the topic? And again, you can always send notes to Jen and I to our email. We're happy if something comes up later or something you didn't want to ask in the group session, be happy to talk about that. One of the things I also want to highlight is we just published our 3rd annual Automotive Trends Report, and it covers just a wide variety of issues in the automotive industry, and we solicit feedback from a lot of people in the industry about what's on their mind, what are the big topics, what are the big risks, how are they managing them? And if you go to Dykema.com, you can access the full report. And I encourage you to do it. It's really pretty fascinating reading about what's going on in the industry. And again, if you have any questions that come out of that report, please give us a call or send us a note. All
Well,
right.
thank you, everyone. We really appreciate it.
Yeah, thank you very much. Have a good day.